Yazdani Law Group.
The refugee claim process in Canada and the United States share a common foundation, both of them protecting individuals fleeing persecution, but the system differs significantly in legal structure, access, and outcome. Here is side-by-side comparison to help you understand the key differences. Number 1, where you can claim. In Canada, you can claim refugee status at the border, inside Canada, or after arrival. You must be physically present in the US or at the port of the entry to apply for asylum in the US. Besides this, in Canada, there is a safe third country agreement. If you're entering from US, you won't be eligible. But this thing doesn't exist in the US immigration. So there is no safe third country under US claim refugee provision. Besides this agreement restricting claim from Canada under STCA, most people entering Canada from US cannot make a claim for refugee unless they meet a specific exceptions like a family tie or unaccompanied minors, something like that. So if you're coming from US, entering Canada, you cannot basically apply or claim for refugee. That's a restriction. So that's one of the major things you need to consider. The second thing is the legal pathway in Canada and the US is different. Two main streams, resettle refugee from abroad or inland claimant, and one mainstream only in the US. Asylum seekers, both affirmative or defensive, they are just one. Claim are heard by Immigration and Refugee Board in Canada, but in the US, claim review by USCIS or Immigration Judge or EOIR. No need to be in removal processing to claim defensive asylum. In the US, defensive asylum only applies if you are in removal proceedings. One more thing, differences. Screening and interview. Claimant undergo an eligibility interview and later a refugee hearing, while in the US, affirmative asylum seekers attend an interview with USCIS, and in defensive claimant, they go before a judge. Besides this, no detention unless security concern arise. Many asylum seekers are detained upon entry, especially at the border to the US. So that's again one big difference between these two countries. Moreover, work authorization and status. The work permit is available shortly after claim is found eligible. But in the US it's different. They must wait 150 days after filing to apply for work permit, and granted after 180 days if not decision not made. And if approved, you become protected person, can apply for permanent residency in Canada, but in the US, If granted asylum, you can apply for a green card after 1 year. So these timing are very important. In Canada, it's right away. You can apply for a work permit right away after eligibility check. You can apply for permanent residency after your file was approved. But in US, it's different. The timing is different. You need to wait for work permit, then apply, and then again you need to wait for 1 year before applying for a green card. What are the philosophical differences? Canada emphasizes humanitarian protection and has a more streamlined process for inland claims. The US system is more litigation heavy, with greater emphasis on national security screening and court-based education. If you are waiting which country offer better fit for your situation, I can help. I can help you assess eligibility, risk, and a strategic option. As a lawyer in Canada and as a provisionally licensed lawyer in California, I can help you with both. Call us at number 877-954-0007.
Yazdani Law Group.